All right, my friends, welcome back to another edition of Run It By My Lawyer. Today's going to be great because we're going over the Donald Trump federal criminal case. And I already did a few podcasts kind of explaining the indictment and the criminal charges against him. This one is going to be different because we're going to go over the nitty gritty of the procedure and what is currently going on in the case. And there is a lot going on in the case, and it's very, very interesting legal issues. And of course, at the very end, we got more dad jokes for you folks. I've been getting so many comments about the dad jokes. I'll start with one that I like that just for now, whet your palate for dad jokes a little bit. What kind of music do elves like to listen to? Rap music.
Oh, brother, this guy stinks!
And today is an especially important day for rap music. It's September 13, which is the day Tupac died. Tupac died September 13, 1996. So on this day, 27 years ago. Anyhow, all right. Let's get started. Can we key in a couple Tupac, a few seconds of Tupac maybe? I did a full podcast kind of on the federal charges against Donald Trump. And the short version, I'll put the link to that podcast. The short version is that the allegation that the federal government has against Donald Trump is that he got together with his cohorts and kind of set up these fake electors that would vote for Donald Trump instead of Joe Biden, and claim that they're the real electors for these various states like Georgia and Michigan and Arizona, kind of the Pennsylvania, like states that were on the cusp of, who won those states. And that then the goal was for our January 6th, where the Congress kind of counts the votes and then Mike Pence, the vice president at the time, signs off. The goal was that they would count the votes from the fake electors and that they would elect Donald Trump as president instead of Joe Biden, or at least that they wouldn't elect anybody on January 6th, and then the status quo would stay as Donald Trump being president. It was kind of a crazy idea. And now the federal government has to prove that President Donald Trump was in on this and was encouraging it and taking steps to get it moving forward. And so it's obviously a big criminal case, right? And now, the charges were filed on August 1, 2023. And that was the indictment by the grand jury. So, and I went over this in detail, so I'm only going to explain it for a second. So the government, they got, what the grand jury does is there's an initial jury, not the jury for the criminal case, an initial jury that just says, do we have enough evidence to at least indict him, so that we could charge him? They said yes. So it's kind of a small hurdle that the government has to do to prosecute it. That right comes centuries and centuries ago from England, back to the Magna Carta, because the British people did not want the royal family just to be able to charge anybody they want, put them in prison forever without a trial going forward, so that to charge somebody, they would have to have a grand jury at least say there's enough evidence to charge him with a crime. All right, so there's two parts to a case. There's the substance, then there's the procedure, and they're both equally as important. The substance is, what did Donald Trump do and is it criminal? And then the procedure is, how are we going to get this case to trial in front of a jury? And now I think the procedure is going to be impossible for the government to get around, all right? And it's already started. So on August 1, that was the indictment. On August 3 was what was called the arraignment, which is Donald Trump showed up to the courthouse and pleaded not guilty. And then on that date, on August 3, so right at the outset, his attorneys made a motion to have the case delayed. And by delayed, I mean there's like a normal course of action. And then his attorney said, well, this is a complicated case. We have a former president. We have, millions of pages of documents. And we want to have the case delayed. And then the judge was, in the way it works in the federal court is that judges are randomly assigned. it's a little confusing how they're randomly assigned. Is it a computer? Is it a person that kind of like says, okay, the next two cases will go here, then the next two here, and it just so happened right when it was filed, it went to Judge Tanya Chuckton. Okay, and Judge Tanya Chuckton is now the judge. And on that day, on August 3, when Donald Trump was in court, pleaded not guilty, they requested that the case be delayed by a lot. And for the life of me, and I've said this so many times and I'm never going to stop saying it, there was a hearing. The judge was talking. Donald Trump was there. Donald Trump's lawyers were there. The lawyers for the federal government were there. And there was no camera there, right? Like they wouldn't let it be recorded. They wouldn't let an audio tape there. Instead, we get these stupid court sketch cartoons that don't tell us anything. And so we can't tell what the demeanor of the judge was, what the lawyers were saying. Like, to me, that is something that is just not excusable. Anytime there's a lack of transparency, I always say there's a problem. Okay, so anyhow, right after that, a week after, or actually a few days after that, then comes the Donald Trump makes a formal motion to have at least a 25-day delay because there is this act that from the 1970s, it was called the Federal Speedy Trial Act. And the act says that the goal for the federal court is that in any criminal case that it should be brought to trial within less than 3 months after it was filed. That's the goal. Now, there are so many exceptions to that, meaning it's kind of, I don't want to say it's a useless act or a useless law, but it kind of is in the sense that the law says every case should go to trial within 3 months unless there's a reason not to, I mean, what case wouldn't go to trial if there was no need not to? Do you know what I'm saying? So anyhow, it's almost like the law is, we're encouraging judges to hurry the F up and get the cases to trial. If there's good reason, they could have it delayed. Okay, so here, what we're gonna, the first procedural issue is that Donald Trump and his team want to get this case delayed forever. All right, if they could get it delayed until next November. And if Donald Trump wins the presidential candidacy, then there's going to be another motion that's going to say, let's just wait until the President Donald Trump is no longer president. Do you understand what I'm saying there? So if they could just get it delayed, and if he could win, then everything is going to be stayed until he's no longer president. That will be that's kind of the goal. So the goal for the government is to have a trial in this case before the next election, which is in about 13 months. And the goal for Donald Trump and his team is to have it delayed. And my goal is to kind of educate you in terms of how this is going to go down and what how the federal court has to navigate this. So the government, like I said, they want to get this case done right away. So what we have here, I'm going to go over this motion that Donald Trump's lawyers wrote. It is one of my favorite motions I've ever read. It's so funny and cleverly written. And the goal for this is that they would convince the judge to delay the case all the way to the year 2026. So kind of a 3-year wait before there's a trial, okay? And it was just, let me go over now how why they're asking for such a long delay. Okay, so the way it works with criminal cases is that the government has the opportunity to investigate and bring their case to a grand jury and then get all their evidence together. And in this case, it took the government 2.5 years to do all that, or just a little bit over 2.5 years. Because from January 6th to August, we're talking about January 2021 to August 2023. We're talking about 2 years and 7 months. The government like I said, investigated everything. And then the law in all criminal cases, whether it's a state case or a federal case, is that then the prosecutor has to give all of that evidence to the defendant, or to the defendant's lawyers, obviously. And then the lawyers for the defendant then have the opportunity to read, analyze, watch, dissect, all of that stuff, the evidence. And this is kind of crazy. The evidence that the government gave to Donald Trump's attorneys included 11.5 million pages of documents. All right, so let's just count that. 1, 2, 3, 4, 5. Right? You think I can count to 11.5 million? All right. So they gave the lawyers 11.5 million pages of documents. Then they also gave, hundreds of hours of recorded videotape testimony, and then hundreds of hours of, like all the January 6th riots, because part of the riot, the way that plays in that kind of so-called violence or actual violence, however you want to say it. I don't have a position there. I'm a lawyer. I'm trying to explain the law here. And part of it was the government is saying that Donald Trump and his team wanted to create so much chaos that day on January 6th that Congress would say, we better elect Trump, or we better, why don't we just hold off on selecting the president today because of all these different votes from the electors and the so-called fake electors and the real electors, so there's so much footage of all of that could be evidence. And so they gave so much evidence to Donald Trump's team that the team is saying, we're going to need a long time to analyze this. Now, as a lawyer, we don't we have to impress upon the judge our position. So it's not enough to say, Your Honor, there's, all this evidence. It's like, look, here's the painstaking task of convincing a judge. And here's how they do it. And I like it. To put this is Donald Trump's attorneys writing the motion to the court. To put 11.5 million pages in some perspective, we began downloading the government's initial production on August 13. 2 days later, it was still downloading. That's, that little buffer circle, right? Imagine how much you like that buffer circle. Imagine that buffer circle going for 2 days and not knowing when it's going to stop, right? When we requested the government send hard drives containing its initial production, which we received on August 16, our technology vendor is now preparing to ingest the files into a document review database, but it's going to take a long time to do. There is a whole technology, darn it, and a whole business of document production and document database. So they have to, after the government did all of that, now Donald Trump's team is saying, we're going to have to hire IT. What is IT? IT tech? Is that right? Or the IT stands for IT tech, or like the I, right? We're going to have to hire computer experts, darn it, to kind of manage all of these pages and all of this data. Then they said, even assuming we could begin reviewing the documents today, because they can't even begin reviewing it because it wasn't downloaded yet, we would need to proceed at a pace of 99,700 pages per day to finish the government's initial production by its proposed trial date. So for Donald Trump's lawyers to read the documents by the time the government wants to go to trial, they have to read 100,000 pages a day. And then they make a good point. See, like I said, they are kind of really trying to hone in on this argument to the judge as to why we need to delay the trial. And that 100,000 pages, they make it a point of saying that it's not just they have to read it, but they have to understand it. They have to analyze it. They have to cross-check it. They have to, do all of this. So every single day, 100,000 pages of documents. One of my favorite parts, That is the entirety of Tolstoy's War and Peace, cover to cover, 78 times a day, every day, from today till the time of jury selection. I don't see a reference to War and Peace and Tolstoy that often in legal cases. Have you read War and Peace? It's like thousands of pages or something, right? Yeah. So, and then the best part is they actually even cite Leo Tolstoy, War and Peace, Vintage Classics Edition. Anyway, so it's just funny that they're saying to the judge, they're trying to put it in the judge's mind how much, how long this is going to take, right? And then it gets better, all right? Stated differently, if we were to print and stack 1.5 million pages of documents with no gap between the pages at 200 pages per inch, the result would be a tower of paper stretching nearly 5,000 feet into the sky. This is taller than the Washington Monument, stacked on top of itself 8 times with another million pages to spare. So you've been to the Washington Monument, Mateo? You haven't been? I've been. It's really tall, right? So they're saying to the judge, and this case is going on in D.C., so they use the Washington Monument as a reference point. They're saying to the judge, if we were to stack all of the pages, right, it would exceed the Washington Monument 8 times over, and then still another million pages. And then they have a graph that shows here's how tall the Statue of Liberty is, about 300 feet. Here's how tall the Washington Monument, 555 feet. And this is how tall that the stack of papers would be. For that many paper, we have to call Dunder Mifflin to produce it. There you go. Someone put Dwight Schrute on the line.
But liquor, our prices have never been lower. Stop heat.
Is that enough of discussion? No, right? Because remember, this is a big request. If they win this case, they could win the whole case because they could delay the trial, and if he wins president, then they could delay it. They could stay it, meaning like it just freezes in time, like Han Solo in Star Wars, and then it just then restarts when he's not president anymore. So this is why I say there's the substance of the case, which is what he did, and is that criminal and everything. Then there's the procedure. If they win this motion, they could win the case just by the procedure. This is what good lawyers do if they could win, on procedure. All right, so they're going to hone in on this more. Yet even this analogy belies the true scope of discovery, meaning about the Washington Monument. It includes only the printed text without considering native files, audio recordings, phone and electronic device image files, and other material that will require substantial labor-intensive review, meaning that it's just the paper. There are also those thousands of hours of footage and recorded interviews. Native files. That means something like, where did the document come from and who produced it? Like who, to see sometimes like, if there's an email, like let's say someone prints a 10-page email, it could have been a doctored email or something. So they have to they could see the native file behind it to make sure that it was properly printed. Do you know what I'm saying? So that's a lot of work they're saying to the judge. And then they're saying government counsel described hundreds of recordings of witness interviews, blah, 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 right? Likewise, it does not consider the large number of additional documents that the government has not, but still intends to produce. The other rule about discovery in criminal cases is that the government has to give the defense attorneys everything it has. Then, if it gets more evidence, it has to keep giving that to the defense. And even if the evidence helps the defense, it has to do that. You ever seen that movie Cape Fear with Robert De Niro? He's a counselor. That was all about this. The prosecutor in that movie did not, or the prosecutor gave information to the public defender that would have gotten Robert De Niro off the hook in that criminal case. But then that lawyer hid that information, So here it's like the government has to give all the information to Donald Trump's team. And then it says, President Trump may request from the government and discovery, extra material or extra files. President Trump may request from third parties extra documents. So all of this, and I'm going through all of this, and I know what some people might think this is boring detail. Some people would think this is boring detail, but I go through it because this is how cases can be won or lost, and this is what we're dealing with. It's like these procedural things. For its part, the government suggests that it has prepared and organized discovery in a manner that will assist the defendant in its review. What they're talking about here is the government is saying, don't worry. We gave them files and we labeled it and we kind of tried to organize it for them. And then the defense attorneys are saying here, regardless of that, we don't have anything that we can do. So it's, that is the biggest reason why they need this delay. Then there's other reasons. And I love the wording here. They're saying that, this case is complex and unusual, for obvious reasons. Then they say this is terra incognita. Have you ever heard that term before? It's Latin. Terra incognita. So I looked it up. So terra, I kind of knew. I'm like, okay, uncharted territory, right? But so the Latin terra was the goddess of the earth. So she's the Roman goddess of the earth. Her name was Terra. That's how we get like terrain, territories, territorial, all of that from the Roman goddess Terra of the earth. So she was a goddess of the earth. And incognita means, like something like we don't know, like a woman we don't know type of thing, right? So terra incognita means like land and territory that we don't know, okay? But I like the way they said it. You know what I'm saying? Joe Samo would have just said probably, we don't know what the F we're going into here, right? Was that more like romantic? We don't know what the F this is, Judge. But no, these lawyers said it more delicately, terra incognita. The protests at the Capitol Hill aside, no person in the history of our country has ever been charged with conspiracies related to the Electoral Count Act. No president has ever been charged with a crime for conduct committed while in office. No major party presidential candidate has ever been charged while in the middle of a campaign, and certainly not by the Justice Department serving his opponent, meaning, Joe Biden's Justice Department. These and numerous other issues will be questions of first impression. So what they're saying to the court is, in addition to 11.5 million pages of documents and hours of recordings and all of that, this is also, what's the Latin term? Terra incognita. I'm going to try to use that one day, And so I'm going to say that to the kids. They're going to be like, whoa, Dad, why do you need to do this? Why are you going to take so? Oh, well, this is terra incognita, And my kids will be like, no, it's not terra incognita. All right. So anyhow, so in addition to all the discovery, this is so unique, the defense attorneys are saying, that every little bit of this case is going to be unique and unprecedented, and that it's going to require extra time. So there's no way we could go to trial within the next 2 years, they are saying to the court, in what I think was a very well written argument. So then they have their own request. This is beautiful. Like what I say about procedure. Listen to what we're arguing here. What we are arguing here is not what we are arguing about, meaning it's not about what Donald Trump did or didn't do. We're not arguing about that. We are arguing about when we will argue about what he did. Do you see what I'm saying? So so there's all these motions just to decide when we're going to have the trial. And that, I remember a long time ago, one time I was going to court, my wife's like, oh, what are you going to court for? Or she said something like, oh man, so the trial is today. I go, no, trial, no. We are going, the opposing lawyer made a request to continue the trial, and I opposed the request to continue the trial. And today it's going to be a hearing about how to rule on the request to continue the trial. Do you see what I'm saying? So anyway, Actually, I take it back. I remember now. It was even one step below that. It wasn't the hearing. What we were bickering about was when we would have the hearing about whether or not to continue the trial. So it was like this, it's called ex parte hearing and it was like what the date would be where all the motions would be filed and heard for the motion to continue. So it was a hearing to determine the date for the hearing to determine the date for the trial. Do you see what I'm saying? So you like that? You like that? You like that? All right. All right. So now the government, the federal government opposed the request by Donald Trump's team to have this federal trial in the year 2026. I do not think that their opposition to his request was as well written as the request to continue. Like what the government is saying is, look, the majority, roughly 65% of the government's first discovery production, in which the government front-loaded the most important materials, consists of materials to which the defendant has functionally had access, are duplicative, or do not constitute important discovery. They call it Rule 16 discovery. So what they're saying is of the 11.5 million pages, a lot of them are duplicative, right? That's kind of funny to be like, wait a minute. I'm on page 8,322,000 and whatever. I think I remember reading this page before, right? So how is that going to help exactly? They're going to have these computer tech wizards kind of analyze every word. And then if there are pages that are duplicative, and this happens a lot in the law, and they kind of go over this, they're saying, because, for example, let's say we interviewed one of the witnesses, like one of the Congress members, and in that we gave that Congress member, a stack of paperwork to review during the deposition or during the interview. That stack of paper might be the same stack of paper we gave 5 other individuals, so that we're going to include it 5 different times. Right? So they're saying a lot of the pages of the 11.5 million are duplicative. All right. That still doesn't help because they still have to know what everyone read. Do you see what I'm saying? Like if there's going to be a witness, they have to know what that witness read. So they still have to know, and plus there's always some lawyer. Maybe they slipped in another page. You know what I'm saying? Maybe so they still have to analyze everything. Right. They say here that a lot of these documents that were produced, they were already like documents that were either public information or Donald Trump already had, like if there were letters between the Congress or if there was, some of these fake electors, the documents that the fake electors were signing and adding and the emails to the fake electors saying, hey, we're going to meet at the Georgia, Capitol building on this and this date and blah, 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 like all those emails, like the president already had those because it was his staff that were CC'd on it or something. So of the 11.5 million pages, Your Honor, this is the government talking to the judge, they already had a lot of those pages. Okay, I think that mitigates a little bit. And they're saying some of those pages were in the National Archives and some of those pages were public records. And then they're saying, there was a third thing that Donald Trump's attorney said. They said, well, Your Honor, we can't have the trial in the next year because Donald Trump is being indicted in 3 other big criminal cases, and the state of New York is suing him. And there's this other, so the 3 reasons to delay the trial was all of the documents in discovery, the terra incognita. This is a whole crazy case that's never been done before. And then the third is he has criminal charges in all these other cases, and he's being sued by the state of New York for hundreds of millions of dollars potentially. So that, we have to have all those 3 were filed first. So we have to have those 3 adjudicated before we have this adjudicated, right? Or at least that we can have them simultaneous, but they have to kind of like, work around the other schedules. What the government is saying here is, like I said, some of the evidence was duplicative. They're saying, my favorite here. In case, this is from the government. They addressed the War and Peace and Washington Monument. In cases such as this one, the burden of reviewing discovery cannot be measured by page count alone, and comparisons to the height of the Washington Monument and the length of a Tolstoy novel are neither helpful nor insightful. In fact, comparisons such as this are a distraction from the issue at hand. which is determining when we're going to have the effing trial. They said it a little bit more eloquently, the government. I've never seen that kind of argument. They don't address with the other cases. They're like, well, we could work around it. We can still have it. Maybe we can have this date changed and this date. I didn't like the government's response. Now, the court has to rule on this motion. The short version, the judge analyzed everything and said to Donald Trump's attorneys, these are my two middle fingers. I'm not going to hold them up. Should I hold them? No, I'm not going to do it. I'm not going to do it. So the judge gave Donald Trump lawyers the middle fingers. If there's two middle fingers. Yeah. Okay. So the judge said, no, I'm not convinced. We should be able to go to trial on March 4, 2024, which is from the date, which is in about 6 months from all this. That's pretty fast, 6 months, or it's like 6.5 months. It would be great, Mateo, if we could hear and watch that hearing where the judge said that. Wouldn't that be awesome if we had video footage of that? Wouldn't that be awesome if we had that type of transparency, Mateo? No, we don't have it though. I don't know why people are not asking for it. But anyway, the bottom line is that's how the judge ruled. There's going to be a trial on March 4. Before that, I have a bet with my friend Tom T. That's all I'm going to say about him. Tom T, you know who you are. We had a bet before this. I said, there's no way there's going to be a trial by April 1, 2024. He bet there would be. I'm still going to win because it'll be delayed past March 4, 2024. Okay, I promise you. There will be no trial with a jury. That starts on March 4 of next year. It's absolutely impossible with what's going on. All right. So that's how the judge ruled. She ruled it. Look, there's a little conundrum. Is that the right word? Some people are saying, well, March 4, 2024, that's right before the Iowa, campaign, the Big Tuesday, this and that, right? Which is correct. But what are you going to do? Starting next year, the whole year, there's going to be campaign events. And she was stuck because she wanted to give the defense, Donald Trump's team, a little bit more, like as much time as possible, kind of. But if she had it a little bit more than 6 months, then it would have been very close to the next election. Do you see what I'm saying? Because that election is in November. So she couldn't get it too close to November. Obviously, she couldn't do it after November because if he becomes the president, then it's just going to be delayed forever, or at least another 4 years before then we restart it. And then they're going to say, well, we have to now look over everything again, right? So the best she could do to try to accommodate everyone was March of next year. What do you think? Donald Trump's lawyer liked that or didn't like that? I mean, they lost. They basically lost with that type of ruling. Okay, so Donald Trump has a new idea. Get this. Are you ready? Are you ready? Are you ready? Here's the new idea. Well, this judge Tanya chucked in, we have a better idea. We want to fire her.
You're fired.
That is so rad. We want to fire the judge. Have you ever heard that one before? I like it. The formal way of saying that is Donald Trump's motion for recusal of district judge pursuant to 28 U.S.C. section 455A. What that means is they are filing a motion in front of this judge, Judge Chuckton, Tanya Chuckton. And, remember, she was, did I say? Yeah. So she's President Biden's nominee for federal judge in the District of Columbia. He nominated her in the year 2013. It was a coincidence that she donated money to his campaign in 2008. That was coincidental. Okay, but that, so, and then she's been on the bench since 2013 or 2014 is maybe when she actually started. She graduated law school in 1983. So she's been an attorney or judge for like 36 years. Anyway, so they're making a motion that she recuses herself. So they're telling her, judge, fire yourself from this case. Right? Those motions never win or rarely win because she's already thought about that. Thank you very much. When this whole case started and when she was assigned a case, anytime a judge is assigned a case, they could automatically recuse themselves that day. She didn't do that. right? So I don't think Donald Trump's lawyers are going to convince her otherwise. Let me go over a couple of their arguments. What they said is, so in Washington, D.C., in that federal court, there was a lot of the so-called January 6th violence cases, meaning those rioters and everything. A lot of them went to trial, the ones that went into the Capitol building. A lot of them went to trial, and a lot of them went to trial in her courtroom. And so, she tried a lot of those cases as a judge, and, the people like pleaded guilty and everything. And in a couple of the cases, the part of what the defendants that were pleading guilty in January 6th that they were saying is they said, Your Honor, I'm sorry that I was violent. I'm sorry that I, threw whatever at a police officer, or I broke a window, or I stormed the Capitol, or blah, blah, blah. I was, led by Donald Trump, and I believed that Donald Trump was the one that was like encouraging us to do this. And I was like, I was misled or misguided, and I've never been in trouble before, and I was doing this because I thought this is what President Donald Trump wanted me to do, right? So they said that to her and kind of to mitigate the sentence that they would get for the Capitol violence, right? So she said, and this is a quote from her, the judge chucked in, this was nothing less than an attempt to violently overthrow the government, the legally, lawfully, peacefully elected government by individuals who were mad at the time that their guy lost, meaning, President Biden won, and peacefully he should, and then the rioters were trying to say that. Then the judge goes on to say, I see the videotapes, I see the footage of the flags and the sign that people were carrying and the hats that they were wearing and the garb, and the people who mobbed the Capitol were there in fealty, in loyalty to one man, not to the Constitution, of which most of the people who come before me seem woefully ignorant, not to the ideals of this country and to the principles of democracy. And here's a big one. It's a blind loyalty to one person who, by the way, remains free to this day. So she said this in October 2022, and she basically is ripping this defendant for following Donald Trump. And then just for the hell of it, she ripped Donald Trump and said, this guy is still free. So what they're saying is, based on statements like that, the judge is biased. She's already made up her mind about this criminal defendant. Do you see what I'm saying? So because of that she should fire herself or recuse herself. They should just say the word fire. That'd be funny in corporate America. They're like, we are recusing you now. Anyway. It's a good, what would be awesome when she said this? I wish we had footage of her saying this to see her demeanor and everything and how she said it. Wouldn't that be nice? Oh, she got to see videotapes of the riot. Why didn't we just write down what happened? Right? Why does she need to see it? What is the benefit of seeing it, Judge? I mean, we don't get to see it. Anyhow, all right. Did I make my point? Do I have to? Okay, cool. Mateo's is telling me to chill out. Well, I'm not going to chill out. That's we should be able to see what the federal court and how they do this and how she said it. I want to see footage of it, but I can't because they don't let it. All right. And another defendant that she sentenced to prison, Mr. Palmer is the defendant's name. She said words like, he went to the Capitol because she's talking about this defendant, despite election results, which were clear-cut, despite the fact that multiple court challenges all over the country had rejected every single one of his challenges. Mr. Palmer didn't like the results. She's talking about this defendant that she's about to sentence. He didn't like the result, and he didn't want the transition of power to take place because his guy lost, meaning Donald Trump. And it is true, Mr. Palmer, so she's talking to the defendant that she's about to send to prison. You have made a very good point, one that has been made before, that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged. And then she, so she's basically saying, because this guy, Mr. Palmer, that's about to go to prison for a January 6th riot, she's telling him, yeah, I understand that you're saying that all these people that encouraged you, like the president, they're not being charged. They're not going to jail. And she's telling him, you're right. That's a good point. So Donald Trump's attorneys are saying that she's biased for comments like that, and that, she's already been tainted, that she's already, she's not impartial, like she's already made up her mind about this particular defendant being the president of Donald Trump. I don't think she's going to recuse herself, but procedurally, this is good. You know why? because it delays everything else because they have to have this adjudicated because they made this motion. She's not gonna agree. But you know what Donald Trump could do? He could appeal that. And if he appeals it, then it'll delay the case, hopefully until after April 1. So I win my bet. I mean, sorry. Hopefully for them after April and after May, because then it's going to be very close to the election. And then once it's very close to the election, there's no way we could have this trial, right? So I think procedurally they did this. Maybe she recuses herself. I think she won't. In fact, I'm positive she won't. But at least then they delayed it by a little bit, and then they could appeal it, and then maybe the appellate court thinks that she should have recused herself. I don't know. I don't think they would, but you know what it will do? It'll delay the case if they go to an appellate court over this, and it could delay the case for another year. Dad jokes, ready? I have some good ones today. Thank you for bearing with me. I got some good dad jokes. And Rami, thank you for sending me some dad jokes. All right. There's a guy that was afraid of hurdles, but the good news is he got over it. What did one volcano say to the other? I lava you. That was okay. Why did the computer catch a virus? It left the windows open. Why do nurses use crayons? Because they have to draw blood. I'll see you next week.